The first fiduciary obligation is to have a quorum.
We're shirking our fiduciary duty already.
Done. We're good. We're good. Good morning, Harvey Lederman, Reed Smith.
Hi, Harvey.
This is, the one of our last speakers talked about topping off the tank with a couple of gallons of oil. This is more like the card you get in the mail every year from your dentist saying it's time for a checkup,
There you go.
like that. But it's actually an honor to be here before the noon hour. I mean, it's like being above the fold in the New York Times. I'm honored to be here with you. This is, I think, my third. We'll talk about that a little bit. This is my third opportunity to spend a little time with you on an annual fiduciary training, and as I've done in the past, I want to we'll kind of do a refresher quickly. Let's see if this works. I'm not sure where I'm pointing, but there we go. I want to do a bit of a refresher just to get our bearings of our fundamental fiduciary duties. And then, as I've done before, I want to talk about a couple of targeted topics so we can drill down. And the two topics I wanted to discuss with you today particularly was, what does it really mean to be loyal? Loyal to whom, and how do you do that? And the other is, what does it mean to be prudent? Since those are both duties of trustees of a pension plan. I included what I considered a provocative scenario. This is torn from the pages. It's one of the last pages, I think, in the presentation. This is a true situation. The numbers have been changed, but it was something that a board has had to grapple with for 7 or 8 years now in terms of its loyalty to members and what does that really mean. And we've been in litigation over that for another system for literally 9 years and not yet resolved that. So I included that. I should have had another bullet point on this slide that simply said questions, because I want to leave a little bit of time for you to ask anything that's on your mind, at least about fiduciary responsibilities. Somebody key me in on where I'm supposed to be pointing this. There we go. So just to get ourselves oriented, let's go back to basics, our fundamental fiduciary duties. These are in the Constitution. The chair raised a question, one of our last discussions about Prop 162 and that provision of the Constitution. That is the core place where we derive our fundamental fiduciary responsibilities. It's also in the Ed Code. Many of these things are replicated in the Ed Code, and these are principles that have been with us for hundreds of years, literally, because the idea of a fiduciary is someone who is responsible for somebody else's money, not your own. And so these duties stem from that very simple proposition that what you're dealing with is somebody else's money, other people's money, that you hold in sacred trust for them. The exclusive benefit rule is exactly that. You have a duty only to use the plan's assets and resources to deliver benefits that have been promised to your members and the reasonable administrative expenses that you necessarily. This is simply to act in the best interests of all the beneficiaries of the system. What Prop 162 did in 1992 was to add to what was already in the Constitution in terms of your fiduciary duties, this precedence idea that while there is a duty, and as stated in the Constitution, among other things, to minimize employer contributions to the system. We can talk a little bit about what that means, because it doesn't mean simply keep contribution levels down. But after certain actions by the governor in the early 90s to slow pay essentially PERS, the people voted in Prop 162 to add this precedence language, which simply says you may have duties of all kind, but your primary loyalty to the members, it takes precedence over every other duty that you have. And that was added in 1992. What has always been in there is that you are held to a standard of a prudent expert. Now, that comes as a shock to some people because there's a difference between the prudent person standard, doing the right thing and using your judgment as best you can. But the prudent expert standard is a much higher standard, and this is all in code. You know, a lot of these standards, you read language in the Constitution and the Ed Code, and you look at it and you say, well, what does that really mean? Well, in the Constitution, it says that you have a duty under the circumstances then prevailing to act as a prudent person in a like capacity and familiar with these matters in the conduct of a similar enterprise with the same aims. That phrase, familiar with these matters, is code. That's the code for expertise. That's where it derives from. That's the language that says you have to go beyond simply having a good intention, and that you must familiarize yourself. And that's part of what I want to talk a little bit. I want to drill a little deeper today about that. What does that really mean to be familiar with these matters? And what it's telling you is that you're going to be held to a standard of having expertise in everything that you do. I don't want to clear the room with that, but we'll come back to that. Couple more fundamental fiduciary duties. Diversification. Long time ago, this was put into the Constitution. The state bought in to the idea of modern portfolio theory. As simple as that. That part of your fundamental fiduciary duties is to diversify the portfolio. And we come across a lot of questions sometimes, especially when we're talking about divestments, that we have that trigger this issue of diversification. And you must diversify the investments. The idea being, as modern portfolio theory, that's how you minimize risk and maximize return. That is the theory of the efficient frontier. That's why we're constantly returning to that as a core value of the system and a core mechanism by which we invest the assets of the system. That's a fundamental fiduciary responsibility. And then finally, one that we don't think about a lot, but I touched on last year, is you must follow the plan documents. A trustee of a trust has to follow the law, and the law is incorporated in your plan documents. And what are your plan documents? It's all those things that make CalSTRS a governmental plan that's exempt from Internal Revenue Service taxation, from federal taxation. It's your documents, your investment policy statement. It's your board policy manual. It's all the regulations that you've adopted governing the granting of benefits. It's your appeals process. All of these rules and regulations are essentially part of your plan document, and you must have loyalty and adherence to what's in your plan document. That's why we spend so much time on truing those up. I think yesterday we had a conversation about how often should we look at our charters. And that's part of this, following the plan document. Because I'll go back, remember that prudent persons, that prudent expert standard, it said, under the circumstances then prevailing. And so you have to keep truing yourself up as circumstances change. And circumstances are always changing, as we know from the presentation on the Pension Solution project. So those are your fundamental fiduciary responsibilities falling into place. Last year, it was very timely for us to have a conversation about ESG as part of this whole project, this whole training, and talk about your special obligations as state officials sworn to uphold the state constitution, and how we could reconcile that responsibility with your fundamental fiduciary responsibilities. I think that was a good conversation, and a lot of that we talked about is now finding its way into the ESG policy and the divestment policy. So that was a good exercise we had last year. As I said, this year I'd like to spend a little bit of time on what it means to be loyal and talk about a couple issues, and then what does it mean to be prudent. So let's talk about what is this loyal? Remember I said the duty to be, a primary duty to the members and loyalty. This board is what's considered to be an interested board. And that has to do with how you get on the board. It isn't necessarily true that pension boards have to be structured this way. You only have to look at New York, the New York Pension Fund, State Pension Fund, which is run by a single trustee. Tom DiNapoli is the controller of the state and runs the entire fund out of the controller's office. You have other examples, Ontario Teachers, for example, which has representatives of labor and management forming a body, and that body then picks totally independent people to sit on the board and exercise fiduciary responsibilities. What's unique about California and these boards in California is that each one of you get on this board from a different way. We have some constitutional officers who, by law, by the Constitution, are on the board. The controller, state treasurer, superintendent of public schools sits on the board. Department of Finance, you have 3 active members of the system who are elected by active members to sit on the board. And then you have public appointees. So you all come from different sources. But, and this is the toughest distinction that we have to make, I think, for this board. I don't just mean this board, I mean any board in California. How you get on the board is not dispositive of who you are supposed to be acting for once you're on the board. I'm going to go ahead a couple of slides. I want to show you a quote here. All right. This is a seminal case from the Supreme Court. And I want you to look at, in the first paragraph, the second sentence starts in the middle there. An employee benefit fund trustee is a fiduciary whose duty to the trust beneficiaries must overcome any loyalty to the interest of the party that appointed them. And look at the last sentence on this slide. There is a distinction between a great thing to do because you all relate to the offices you come from or how you got appointed or how you got elected. And you've been entrusted by those people to sit on the board. And in some cases, there was no choice. It's just etched in it's etched in the education code that this office shall sit, the Department of Finance shall sit on the board. But once you're here, you're not representing the Department of Finance. You're not representing the state superintendent of schools. You're not necessarily representing just, there's been a determination. You know, we have a law in California about incompatible offices. There are some offices in the state, in local government, that are simply deemed under law to be incompatible with each other, and you can't serve in 2 offices like that. Try to give you an example. For if you sit on a air control district, for example, and you also sit on a city council, and they both have zoning and emissions obligations, it's possible those will come into conflict, and that will run afoul of the incompatible offices law. There is no none of you are deemed to be sitting in incompatible offices. The controller's office is not incompatible with this board by definition because it's required to sit on this board. So that determination has been made. Same thing with the treasurer's office. But notwithstanding the fact that legally it's not incompatible, You then have the fundamental fiduciary responsibility to put the needs and the interests of the members and beneficiaries of the system over the offices that you came out of. And again, I say that is so difficult. It's something to have in your mind and to grapple with, because one of the strongest policies that these boards deal with is the idea of conflicts of interest. And conflicts of interest aren't just your own personal, like, I own stock in a company we're about to invest in. That's the easy stuff. We don't have to deal with that. The hard stuff is the conflict between, should California, for example, would the Treasurer's Office, for example, just love it if we had a $5 billion allocation to infrastructure and the Treasurer wanted all of that to be spent in California? When you come here, you've got to say, is that really in the best interest of, and how do we handle that under our obligation to diversify, to control risk and reward? So I don't mean to pick on the Treasurer's Office, Jerry, but there's an example where the Treasurer may say, we would love all this infrastructure spending to go on solely in California. Don't put your money in Nevada. But it may not be in the best interests of the members to concentrate all that in one location, in one geographic state. So there again, that has to win out over the considerations of how you got here onto this board. Great.
Harvey, duty of loyalty, I've heard different views on that in terms of loyalty to future members, that the loyalty is to the trust and to the system. And it's not necessarily the bodies that are in it. Do you have an opinion on that?
Yeah, it's sometimes said that there isn't a loyalty to future members, and it's true because they don't exist. It's hard, it's very ethereal to think in terms of owning a duty to somebody who hasn't been born yet. But let me also remind you that all we talk about is the long-term sustainability of this program. We're talking about fully funded by 2046. Well, the people who are coming in and going to be members in 2046 are not born yet, possibly. And they are the future members. And much of what we do is for the welfare and the benefit of people who are not yet members of the system. So I do think that there is an obligation, a fiduciary obligation, not only to current actives and current retirees, but for the perpetual flow of members into this system. And that we do keep that in mind. We do act in a fiduciary capacity. Our long-term investments are meant to extend over a lengthy period of time. A lot of what we do is to future, yet unnamed, yet unknown members of the system. Does that make sense? Other questions at this point? Okay. Paul.
I actually had the exact same question, but let me just put you a little on your answer. So does that mean we have sort of an equal obligation to all of our members, retirees, inactives, actives, and yet to be members?
Yes.
Okay.
Equal is an interesting question because I think we have to be more sensitive than just basic equality as the concept. By that I mean active members have certain needs and interests. Retired members have certain needs and interests. As you balance the interests of active and retired members and anticipatory members in the future, you want to weigh all of those considerations and treat them fairly. It doesn't mean that you'll necessarily come out where everybody is treated equal. I think that's what I was trying to say. But you want to balance the unique interests of those different members and beneficiaries of the system. So your balance may come out different, especially based on timing, for example. of various decisions. So it may not be equal in every decision, but there may be, for example, what you don't want to do is sacrifice long-term gains to meet short-term needs, for example. So while you have a cash flow issue, perhaps, and you want to liquidate portions of the portfolio, you also know that over time you're going to need to have that money growing over time to pay future benefits as well. So you're constantly balancing all the interests of the membership, not just, and it may not end up not treating everybody equally all the time. Does that make sense?
Yeah, I mean, I don't think we need to go into individual examples, but I think what you're saying is, yes, we can't favor the interests of one group over another, and when we talk about groups, we also talk about future members of.
Correct.
Okay, thank you.
A little bit different, but back to the loyalty definition and fiduciary responsibility, regardless of representation that you have or how you
Yes.
got yourself onto the board. And so how do you reconcile that with decisions that members need to make around recusal or abstention or things like that? So I'm just trying to reconcile that in my head.
So let's talk about abstention or recusal. Abstention in the context of a fiduciary board is tricky. The obligations are mandatory obligations. It literally says the board shall do this and the board shall do that. It also says that each one of you are fiduciaries and you can't simply leave it up to somebody else to do the voting. Recusals and abstentions should be done for very narrow act of the board. The active members of the board recused yourselves from that determination and abstained from the vote. But a fiduciary is expected to act. The other thing is that not voting changes the composition of the board. That may be a subtle interest, but the Constitution, the fiduciary part of the Constitution, Article 16, Section 17, has a provision that says you can't change the composition of an elected board like this that has elected members on it without a vote of the people. It's that important that the balance that this board has been constructed with and is supposed to operate with gets thrown out of balance if people recuse them, if people abstain from voting on certain things for reasons that really aren't required, like conflicts of interest. And so one of the things you want to be mindful of is not depriving the membership of the full participation of the board. And so you want to exercise. You don't want to abstain. The default setting should not be if it's a difficult thing or my office. This is where it's really hard because the office that appointed you, the office for whom you sit, Michelle, in your case for the Department of Education, may take a position, for example, on a bill. When you come here, you're not an emissary of that position. You are looking at that bill through the lens of what's in the best interest of the membership of this system. It's tough. And I know that puts you sometimes in a awkward position, in a difficult position. But truly, as a fiduciary, your responsibility is to actively participate in the management of the system and not abstain from those difficult decisions. I didn't tell you it was going to be easy. But waiver motion is pending. Interesting.
That's interesting.
Yeah.
That's interesting because I've always heard the interpretation is that they are a no.
Yeah. I'm betting with Madam Chair.
Are you going with her?
Yeah.
Yeah.
Okay.
I don't know. We'll have to research
right.
that one out.
We'll research.
Somebody-
She threw down the category, yeah.
Yeah. Harry, did you have another question?
Just about the composition of the board and abstentions. So what about when there are vacancies on the board? Does the same argument flow?
Yes.
That
Yeah.
the composition of the board is
In my view, leaving vacancies on a board composition has a constitutional defect.
I think that's what we
That's-
based our, I
that's-
think that's what we
That's
based our
significant
letter on.
statement.
Yeah, no, that's, yeah.
I understand.
Yeah.
We've had a defect.
Drew?
Just a quick question. To the extent you are a designee on the board and you're casting a vote for someone else, your views might be different than the person who you're representing. Can you talk about kind of that conflict where, you're a designee, your role is to do what your principal, to carry out your principal's guidance. And what if, you yourself have an internal conflict regarding
The office holds the position on the board. So if you are a designee, you are supposed to be carrying out the wishes of that office, in your case, the treasurer's office, not your own personal views. For others, it's different. In many systems, there are alternate members who don't sit as ex officio, but if someone's absent, there's an alternate retired member takes their place. And in that case, they should be carrying out their own personal values and state of mind. But in your case, and in the case of the other represented departments, it runs with the office. And so you should be carrying out the interest or as expressed by the office holder. Okay. Let's see. We touched on this a little bit, and I don't have to go into too much detail, but the idea here is, and this is really a difficult balance sometimes to figure out what's in the best interest of the members. I mean, the Constitution says members and beneficiaries of the system. Because we have active members, we have retired members, we have deferred members, we have people coming in and out of the system, we have future members that don't exist yet. And this is just something that means you have to struggle with that. You have to identify what are those interests. You're given great discretion. This is one of the reasons why the board is given, if it was a corporate board, it would be the business judgment rule. For you, it's the exercise of discretion that won't be overturned if it's reasonable, that you're allowed to make these judgment calls and balance these various interests and come out one way or the other. So when you do this, you want to, as I said to Paul's question, you want to consider what's equitable and fair to all of these constituencies of members, where loyalty should run once you walk through the door and take on the mantle of being a board member. I want to talk a little bit about what does it mean to be prudent. We talked about the prudent expert standard. This is supposedly an objective standard, not subjective. In other words, it's not subjectively based on what's in your own mind, what's in your own heart. Everybody comes on wanting to do well. The exhortation here is for you to, if you're not an expert in a particular area, you have an obligation, a fiduciary obligation to go out and get it. And we saw a really good example of that at the last board meeting. I think it was in June. Price Waterhouse was here because some of the questions were, we got to get our arms around how do we even know what right questions to ask about cybersecurity and technology. What are you asking in this area? They gave you 5 or 6 slides of important questions that you should be asking to understand. And we went through the same process just a few minutes ago with the project, the pension solution project. You have people, you have outside experts that you rely on to translate for you what's going on. That's your responsibility as prudent experts. That's what being prudent means. You actually have, because you don't have the expertise, you have a duty if your fiduciary duty includes a duty to delegate to others to go out and get that expertise. You rely on staff to do it. The most important thing is know how to go out and get that expertise, how to bring it in-house, how to question it. There's this wonderful bumper sticker we used to have called Question Authority that you saw everywhere. Question authority. You know, the definition of an expert is somebody 25 miles from home with an opinion. And not every expert's an expert. So you can't just bring somebody in and say, okay, you're an expert, run with it. You have to come back. You have to probe them. You have to use your common sense and get an explanation if you don't understand it, because ultimately you're making the decisions and you need to be able to understand these things. Furthermore, you can't just set and forget it. We had the Supreme Court, it's now 2 years ago, had a long discussion about this over the choice of investment options in a 401k program. And basically, the board of trustees for that program essentially, it was an ERISA plan, and they essentially picked a selection of investments that people could choose to go into, and they just left it. They never bothered to monitor it. And it turned out that it was, over time, it became higher priced than other options, similar options that were available. And the court basically said that there was a breach of fiduciary duty by not constantly monitoring those choices and making decisions. Remember that phrase, under the circumstances then prevailing. And as circumstances change, you have to then monitor what you do. So we do this all the time. This board is perfect in its approach to constantly monitoring and updating the investment choices. Very important to the process. I had to use the verb in the last bullet point, I'm sorry. But it's really true. Process is more important than the end result. You are not a guarantor of the end results. Anybody who knows that, who made a decision to go into tips or commodities a few years ago, turned out to be a lousy bet, right? But if the process under which the fiduciaries go through making those selections and making those projections and relying on past performance and going through that kind of a process, if you go through that process, you're not going to be second guessed. You won't have breached your fiduciary responsibilities simply because the outcome didn't come out the way you thought it was going to come out. This court says it pretty well. Let me see if I can highlight for you. I don't think I have a pointer that works, but I can think of the middle paragraph here. The test for determining whether a fiduciary is satisfied his duty of prudence is whether the individual trustees, at the time they engaged in the challenged transactions, employed the appropriate methods to investigate the merits of the investment and to structure the investment. So that pretty much says it all. You're not, hindsight 2020, that doesn't make you a bad fiduciary if you went through the right process at the time. I don't think we need to go through this scenario, but this is something I selected to try to highlight for you, that the difficult decisions of not leaving the hat of where you came from outside the boardroom when you come in here. This is a board that had to struggle with the downturn in the economy and the impact on its plan sponsor, and make decisions on the best interests of the membership, even though there were people put on the board by the plan sponsor, by the employer, who had one view, and retired members had a different view, and active members had a completely different view. A decision was made. A couple of dissident retirees challenged the fiduciary duty of the board in making those decisions. That case has been up and down to the Court of Appeals twice now heading for trial. And it's the sole question is, did the board give precedence to the interests of members over the interests of the employer? Or did they just ease the employer's contribution rates despite what was in issue?
Harvey, you said something that was interesting to me. You said it had been to the appeals court twice.
Yeah.
How does that happen? I thought once a decision was made by an appellate court, that the only right of recourse would be to take it to a Supreme Court.
Well, what happened is that the allegations were made in this particular case. We blew it out of the water at the trial court level on the face of the pleading.
Right.
And then that was appealed. And the court said, nah, there's probably enough pled in there that they ought to be able to go through the rest of the case. So send it back down.
That's, okay, it was sent back down.
Then we went through another 5 years and one summary judgment in the case. No dispute over the evidence. That was appealed. Court of Appeals said, yeah, maybe we need to gather more evidence. Maybe it should go through trial. Now we're sent back to trial.
So we could actually go back
9
to
years.
it could actually go back to the appellate court again.
Oh,
then,
it
too.
will. Oh, I
Yeah,
absolutely will.
Wow, how crazy.
Absolutely will.
All right.
Okay, I want to open it up for any questions that you may have and be mindful of the clock.
Lynn?
Thank you. So this is an interesting example that you gave us. And is it similar, is the central question similar to what happened in the New York City bankruptcy when the employee union stepped in and made the city a loan so the city would continue to operate? The 1970s. I don't know what the case citation is.
Which bankruptcy?
The New York City.
Oh, in the New York
Yeah.
bankrupt, yeah. They're very similar. Little bit different. The analysis there was the same. That's the, I'll remember, it starts with a W. I'll come up with the case name. I don't know if you're aware of, when New York was in the 70s, was in dire financial straits. The teachers' retirement system made a loan to the plan sponsor, to the city. That entire case focused on the process by which the teachers' retirement board went through the analysis before they just made the decision to make that loan to the plan sponsor. And it's a good lesson because they talked about all the information they gathered and the deep analysis they went through, and they grilled Felix Rohatton for days over the true finances of the city. And then they put in safeguards for the loan. They took pledges of property, for example, as collateral to collateralize the loan. So the whole case was an analysis of the due process and the prudent steps that board had gone through before it made a decision to lend money to the plan sponsor, the city, and found that, in fact, that they had discharged their fiduciary responsibility because it was challenged by retirees.
And I think it's an interesting case too, because I brought up the question, they were arguing that if the city had gone bankrupt, then their members' jobs would have been imperiled, and which would have imperiled the fund because they wouldn't be accepting or collecting any more contributions. So how do we apply that type of a situation where we're looking at discount rates and funding contributions?
Well, we have a case like that in California, exactly like that, the Bant case that came out of San Diego, where the court specifically talked about it is permissible for the board in considering contribution rates and making actuarial determinations to take into account this job security of the members of the system. And that is an appropriate consideration, not dispositive necessarily, but an appropriate consideration to take into account in setting contribution rates. And we deal with this all the time because we have a lot of plan sponsors in distress. And how hard to, our boards are always how much to put on the accelerator on contributions and when to break and how to smooth that over time. And the actuaries come up with all kind of methodologies to try to collect their, they're a percentage of payroll. They're not just a raw dollar number. So as payroll shrinks, as our retiree population increases and the payroll base decreases relative to the retiree base, percentage of payroll as a methodology in some cases doesn't work very well any longer. And so if you have layoffs and furloughs that we went through in 06, 07, they do impact the funding of the system. So it's an appropriate consideration to put in the mix.
Thank you.
All righty.
Other questions?
Paul?
Yeah, I just want to follow up on that because, I mean, at one extreme, I mean, we don't set contributions, but let's live in a fantasy world where the legislature actually set contributions that were needed based on our actuarial assumptions in the actuarial reports. A high discount rate means low contributions helps employers, and therefore potentially the number of teachers who are employed, but questionable whether we then have enough coming in to meet all of our obligations on a long-term basis. And you can flip the situation with a lower changing contributions how that would affect the number of active teachers. So I'm wondering how in the scheme of all of the other considerations, how we would factor in that consideration.
It's very important to separate the assumed rate of return, which has its own method of being derived based upon all kind of market analyses and things. That is very different from the methodology by which you collect contributions. And the actuaries do separate those two, and will tell you they ought to be separated. Whether or not the discount rate causes plan sponsor stress or not should not impact your determination of the discount rate. The discount rate is a projection based on capital markets projections and other things that have nothing to do with the fiscal health of the plan sponsor. Once you arrive at the discount rate and you see the impact that it might have on the ability to collect contributions, there are actuarial methodologies that are available to you to either tighten up or ease that impact. Smoothing, for example, phase in of contributions. This isn't all applicable to CalSTRS because, like you say, our rates are, with some exception, are pretty well cabined by the statute. But my recommendation has always been that don't put in the discount rate discussion the issue of can the plan sponsor pay it. Keep that separate. You have tools to deal with the ability to pay and the timing of those payments, but that shouldn't bleed into determining what the appropriate assumed rate of return is of your assets. That's dictated by asset allocation and capital markets projections and other things that have nothing to do with the financial capability or plan sponsor. Okay?
All right. Thank you, Harvey.
Other questions? Thanks very much.
I did try to do a real quick search on abstention votes on Robert's Rules of Order. And like anything else you find on the internet, this is the official site. So it says, in the usual situation where a majority vote or two-thirds vote is required, abstentions have absolutely no effect on the outcome of the vote, since what is required is either majority or two-thirds of the votes cast. On the other hand, if the vote required is a majority of the two-thirds of the members present, or a majority or two-thirds of the entire membership, an abstention will have the same effect as a no vote. Even in such a case, however, an abstention is not a vote and is not counted as a vote. That's clear as mud, isn't it? And then the other official site says, while it is the duty of every member who has an opinion on the question to express it by his or her vote, yet he or she cannot be compelled to do so. He or she may prefer to abstain from voting, though he or she knows the effect is the same as if he or she voted on the prevailing side. So it's like, okay, it can be a yes or it can be a no. We might want to look into that a little bit further, Brian, if the blue.
Illumination there. Thanks very much for your time.
Thanks,
this
Harvey.
morning.
All righty. Jack, moving on to charter schools.
Yeah, Rick's gonna join me for this.
Come on up, Rick.
And really, this is meant to be a feedback loop item, really making sure that what we heard from you at the last meetings, the questions and thoughts around how we want to proceed looking at charter schools, if we've captured it in the scope that Rick and David, who's out of the country right now, are going to help shepherd through the organization. So at the last meeting, we had kind of two broad sources of information we heard in our Audits and Risk Committee. Some of the issues we've been finding in the charter school audits, and we'll be proceeding with a special risk assessment in that area. And then in the research piece that Lisa and her staff presented to you, you heard some changes that are going on relative to charter school elections and their participation in CalSTRS. And then the third item that was, I think, the cloud over the conversation is the witnessing of increasing financial distress that is obviously evident in the charter school market. So, as I see those three items, the audits, the research around election patterns, and the financial stress issues, those kind of fall into impacting two buckets of our work here. One is the financial actuarial side of our operation, and the other is the member itself. Does it affect the members? Does it affect how we work with the employers, how the employers make these elections? So we try to capture those aspects of the issues in this short write-up for you. And then we thought we would present it to you really in two legs, really starting most importantly with the financial issues in November, and then following up with the member-employer issues at the February meeting. And then, although we're not here yet, in item 14, which is your draft agenda for November, there would be a companion piece that Robin would also present around looking at potential, if there were to be financial distress in our traditional non-charter school educational market, would that in any way pose financial risk to CalSTRS or a disruption of contributions that we would need to make sure we understand the financial and legal implications of? So that's the piece. And then also I want to make sure you saw, for the public record, you received a letter from the Charter Schools Association, and they've offered to make sure, as experts in their obvious area, to provide information and perspective on this item as well. So we'll reach out to them and understand what they might provide us. So we would proceed to work all those different sections we've presented to you with, as I said, Rick and David pulling together all of our staff in the organization around that. And Rick, were there any pieces you wanted to pull out for the board or highlight in the item? Oh, okay. Okay. So was there things we missed, or you want to amplify differently as you kind of saw that short write-up? Or if we're good to go, we will go forth.
Of course I have comments.
Okay, it's good. It's all right.
So along the lines of financial and bankruptcy issues, just because I'm very familiar with a charter school in the Reading area, and they did this, when we take a look at bankruptcy issues, let's not forget that there have been charters that have declared bankruptcy in order to skirt their obligation to collective bargain with their recognized exclusive bargaining representatives. And so that has been a technique that has been used. So let's.
No, thanks for flagging
So
that.
it's not just a straight bankruptcy, that there are other agendas declaring bankruptcy other than fiscal, I guess.
I appreciate that. And this is a heavy piece. We need to figure out what is our responsibility also relative to this. Should we be having some financial analysis, early warning system here, or do we rely on other state agencies like Department of Education and using their information to better inform us? So I think one of the takeaways I had from our discussion with you at our last meeting was clearly we want to gravitate the role of counselors from a more passive, I think, party around this issue or to a more active role. And I think that's one of the takeaways, where there could be legislative implications from this or staffing issues and how we think about this. Yeah.
Then under the whole election section.
Yep.
I kind of have a pet peeve that so many entities talk about Social Security as a retirement system, and these are people's retirement. Social Security is a safety net. It's not a pension. It's not a retirement system. And I think a lot of charters go this route,
Yes.
which kind of irks me anyhow. So I just had to get that out. If we explore the entity responsible for granting the charter, I think we need to make sure that we look beyond districts, because when a district declines to approve a charter, they have a right of recourse to the county. The county can approve one. If they don't approve one, they can always go to the State Department or the State Board of Ed. And there's been times that charters have gone directly to the State Board of Ed. So there's different levels. And if we're talking about entities that are responsible, if charter schools go under, I don't know if the Board of Ed has had that kind of discussion, if they are responsible. So I think that we just need to be part of that. That's definitely part of the whole legal issue.
Okay. Thank you.
And I guess, my final comment is, I know we have the timeline, but this is a really complex, hot button issue. I don't want us to rush our research. I want it to be really thorough. So let's not be hindered or handcuffed by the deadlines.
All right.
And I appreciate the Charter Association's willingness to work with us. There are going to be entities on all sides of this. They will all have their own agendas. We want to try to get as unbiased information as we possibly can. So we'll have state and national constituency groups. And even our state and national constituency groups are torn pro and anti-charter, so it does get very convoluted. Let's reach out to academic studies if there's any out there. I just want us to be aware of the drivers of the research if we do that.
Great. Okay, that's great feedback.
Are there any other comments?
Anything else you all would like included? Yeah.
Paul?
Thank you. I think this is a really good outline, and I'm glad, Jack, that we're also looking at traditional public schools, and in part because I think there are, as we look at charters, there might be some legal protections that we might look at, and I think some of those legal protections might already be applicable to the traditional public schools, so it would be good for us to understand those. I know this is a very large topic. I do think we need to make sure that we're focused on, sort of looking at this from our fiduciary duty, which I don't know whether our fiduciary duty extends to people who are teachers and are not in CalSTRS. but in other words, I think the issue here is certainly not are charter schools good or bad. That is not our issue. Our issue is how does the way in which charter schools are created and operate, how does that affect those to whom we have a fiduciary duty, and those to whom we have a fiduciary duty, as Harvey made clear, it includes future members, but it doesn't include people who are teachers and will never be members. So just to make sure we focus the conversation in that way. I mean, I think the conversation both in terms of talking about the traditional public schools and the charter schools is really on the the teachers, right? It's really on their and our responsibility to ensure a good retirement for them pursuant to the laws and Constitution and everything that establishes CalSTRS.
Sharon?
And I would just add, Paul, that it's looking at the potential growth of charter schools in California and the implication on our membership. To me, that's kind of where I look at our fiduciary duty and say, as we, get contributions in from active teachers in order to, invest that money, have returns, pay that out to retired teachers. I think part of the conversation came out of if charter schools grow and if those charter schools don't choose to have CalSTRS as an option, what are the implications? So I think that kind of idea of growth, we don't know what that will look like, but certainly asking those questions, I think it's a big part of, the questions I have for the impact on our system.
Yeah, I think this might be an interesting topic, Karen, for you and Sharon to raise at your fiduciary workshop coming up, because you're going to be with all the other teacher systems in the country, the major ones, and it'd be interesting if they're talking about this with their boards too, since this is a national phenomena. So it'd be, if you can give us any feedback from what you hear from other trustees, that would be great to hear.
Absolutely. Righty. Anything else?
Is that it?
All right.
Alrighty, thanks.
Thank you, Ray.
So then let's take a look at items referred by committee for board decisions. Steve, did we have any? I didn't think so either, so I'm glad we're on the same page about that one. Any new business or review of information requests? I don't think we have any. Harry, go ahead.
Sorry.
Oh, go ahead, Steve.
Did you want the information request? I did pick up one.
Oh, good.
Was on item 9. So with regard to the future reports on the operating budget, I think there was a request to have included certain pie charts covering 3 years for comparison's sake.
Super.
So have that included in the future.
Good catch.
Thanks.
I did not catch that one. Harry?
So I looked at the agenda for the November Investment Committee meeting. I communicated with Tom Unterman this morning via email and to Chris. That day is really, really long. It's like 28 items on the agenda, including the interviews for the real estate consultant. So I just wanted to get the sense of the committee, the board is the committee, on 2 options. One is to have a subcommittee of folks, maybe 5 to 7, or whomever really wants to be on it, and or for us to meet on a separate day to do the interviews. I don't think it's a good idea for us to interview our consultants at the end of a day. It's just, we won't, yeah, it's not a good idea. So we can meet on a separate day, we could do a subcommittee. Brian, am I within? We're close.
Jack, what are we?
No, I'm just trying to I want to get a pulse of, if Tom as the vice chair of the committee and I communicate via email, there's only 2 of us, I get a sense of where people are at, and then we can then make a decision.
So Jack, what are?
They said that we would all be interviewing them. I thought that was the poll this time.
I'm sorry, I
Yep.
interrupted Michelle.
Hang on, guys. Let's go through the questions first. Lynn, are you same topic?
It's on the topic, I have a comment, not a.
No, that's fine. So Harry, you put it out. Let's go to Michelle.
Sure.
And then while we're having this discussion, Jack, if you'll take a look at what you think are, we're scheduled for 3 days in November, what that agenda breakdown might look like. Go ahead, Michelle.
Mine was just procedural, and it was a question actually of Chris, who said yesterday that the RFA had anticipated the full board would be involved in the interview process, and if we weren't, that we needed to contemplate that in the RFA when they applied. And so I just wanted to know if we actually could go against the process that we had already laid out in the RFA.
Well, Chris Allen, Chief Financial Officer, I instructed the procurement staff to make it optional. So it hasn't been posted yet, the RFP. And they'll make language optional about how the finalist presentation looks. It could be the investment committee or a subset thereof, and that way you guys have time.
Okay, and so we're going to ask them to be prepared for either one, okay? Lynn?
Thank you. I think, Harry, to your question, the controller feels it's really important to be part of the interview process for board consultants. And so either way you want to do it, if it's a full board meeting at the end of the agenda, or if it's a subcommittee, I think the controller's office would like to be part of that process. Thank you.
So Jack, coming back to you, what do we look like in November?
I'm just scanning all the work plans for November, and those are pretty strong, actually. We haven't gone over item 14 yet, but that one, just for the board itself, is if you want to just, while we're on it, we might as well just look at it together since we're talking about agendas. And I was going to ask you not just to look at the agenda, but if you'd like it in a different order.
We have a new one at our seats.
Yeah, we made
Revised.
two changes in it in response to a board member's catch. One is we certainly didn't want the review of counselors' funding levels and risks to be on consent. So that's not only is it a discussion item, but it's actually one of our most major items of that agenda. That was on the amended one, item 14. And then we added the item I just mentioned that Robin will present around distressed employer contribution collection. So, if you kind of look at the cluster of items in there that are significant, we have a financial statement review, which is, that's the month we conclude our financial statements, which is so important and takes a lot of time. We've got, again, a technology management piece, and we've got the actuarial piece. We have a retirement readiness, a research piece to present to you. So it's a full agenda for the board itself as well, just like the investment committee. And then I've got the other committees on my screen here. But before I get to those, do you like that order, or I thought we should, as I looked at it, I thought we should pull up item 14 on the funding risks higher in the agenda. Even though normally we start out with those action items, they're rather. They're not significant issues in those action items, and the legislative review could be done later in the meeting. I'm kind of inclined while you're.
Let's put that as our first informational item.
Yeah, okay, so we'll move that up in the item. And then for the other committees, I got them right in front of me on the screen here.
And actually, Jack, I'm looking at the charter school and the financial statement review.
Yes.
We've already taken, a pretty decent look at the budget. I'm thinking the financial statement review and charter school project would even come before those two. So like if we did the funding levels and risk, and then the financial statement review, charter school. I guess I'm looking at putting the federal and legislative reviews, state reviews, and your report further down and bring everything else up.
Yep. Okay, got it.
All righty.
We'll do that. And then just back over on the committee structure. Audits is a very real agenda, that meeting. It's probably the most important committee meeting of the year, where you have a presentation by Crow, and we all have needs to be attentive to that. So that's going to take some time for sure. The Benefits Committee is also meeting and going over the annual, you went over the agenda, but the annual member satisfaction survey and some service delivery presentation. Brian, it looks to me like you've got a reasonably full agenda for Governance Committee, in fact, looking at this.
Comp does too.
And comp, we carry over some of the discussions you had earlier. So basically, bottom line is every committee has an agenda, for that meeting. So it is.
So
to this time it was 2.5 days. You probably have a little time in there for something else.
Well, little time is not 3 hours for interviews.
Yeah,
If we're going to have a full day agenda in
Yeah.
investments and then another 3 days of interviews or another 3 hours of interviews, I think that would
Yeah,
probably impact that
yeah.
possibly too much.
What I might suggest is you do something also as a contingency till Chris sees the bids and knows, we're all guessing that there's 3 good bidders and all that stuff. We don't know, but it'd be nice to schedule your time so you've got something held. But, you may want to change that if you only get 1 or 2 bidders, for sure.
So Harry, were you thinking of having because it's not how do we go about this? Brian, the investment committee yesterday talked about having the full committee do the interviews. But in consideration of the time, is there a way now for the investment committee to make a decision that they want to have an ad hoc committee do those?
There is, because this is a ministerial act, and under your specific delegation of authority in the board policy manual, you have final authority over board and committee agendas.
When you say you, are you talking the board?
No,
Or
you, the chair.
Me personally?
The chair.
Okay.
So this would be your oversight over an agenda, and so you're making a decision on the future agenda and how the item will be handled. So I believe, since it's ministerial and you'll have a vote of the board, which is the same as the investment committee, I feel comfortable that you could have a vote on
whether we did a subcommittee
on
or
whether there's a
or the whole
desire to
committee.
do a separate committee.
Terry, you want to make a motion?
I just, just the comfort level, is there anybody have a strong opposition to us having a subcommittee? Okay, great. So we'll do a subcommittee, and everyone will be invited, which will be on a separate day. We don't have to identify the day today, right?
No, we'll publicly notice.
Good, okay. So we'll do a subcommittee, and we'll send out an invitation.
That works for me.
To anyone can attend, and everyone on the committee is welcome to be part of the subcommittee. But the interviews will be on a separate day. So we just have to coordinate the date.
Yeah.
Good.
All right, that sounds good. Perfect, because I'm going to bring one forward that's very similar to that. So yesterday when we,
Halloween?
oh, there you go.
We could all be in
Yeah,
costume.
yeah. So when we had the legislative update, Joycelyn did get back in touch with me, and do you want to come up and talk about those dates? So what I'm going to ask the board to do is consider if the decision point now for you all would be, should we use the delegation that you have given the chair and the vice chair to make decisions on legislation that comes before the legislators across the way, before we're meeting in February, right?
Meeting in February, from February 7th to February 9th, but the introduction deadline will be sometime in between February 18th and February 27th. And the bulk of the bills are introduced in the last 2 to 3 days.
So the next meeting for us to be able to take a position is 2 months further down the road.
Is in May, which is after most bills have moved through their policy committees and maybe even the fiscal committee.
Or do we want to, so I'll have Joycelyn go back over the dates, but the decision I want you all to think about and what I'd like us to make is if you want to leave all that to the delegation that you've given the chair and the vice chair, or do we want to set a temporary date for the whole board to come together to take a position on legislation? Alrighty, so let's go through the dates again.
And an additional consideration of the delegation authority is that I think stakeholders were looking at it and contemplating it as a function when there was an emergency, if you will. So a bill was gutted and amended at the last moment. Something got introduced at the very last moment, and there wasn't an upcoming board meeting where a position could be taken. In this case, it just happens to be that the board schedule is set for February and May as those meetings kind of around the bill introduction deadline. So by virtue of having set your schedule that way, we kind of miss, and I can go through those dates, we kind of miss that window, but it's not because of any last minute introductions or last minute changes to a bill.
And we always have the choice to not take any position on them until the May meeting. So I'm asking the pleasure of the board.
Can I ask this maybe a little?
Sure.
Being the vice chair.
Yeah.
So we have, as a board, already voted to delegate us this authority originally, right? So are we having to have this?
No.
So I guess I'm just.
Well, for me,
Trying to
when we
understand.
talked about it, we talked, the last time we went through this was we talked about what items that the board would be comfortable for us to take a position on, and what
Right.
did they want to hear
Okay.
And so the board made a decision, we want to hear these pieces of legislation. These ones we're comfortable if you take a vote on under the
So
delegation.
do we need to, so I guess I'm asking, do we need to have this conversation then each time we have a batch of legislation come up to decide?
I don't think so, because I think we're going to be able to play within the timeframes. I think it's just this time, because the
It's
time frame
longer.
is so weird,
Okay, okay.
according to how we're meeting.
I was just wondering
And
when,
the deadline for introduction, and,
got it.
I mean, if Joycelyn's team can come up with analysis prior to our meeting in February for anything that's introduced then we would be able to take positions as a board. It's what comes up after our meeting, between our May meeting, between that February meeting, and the deadline, the legislative deadline, and then our May meeting.
And the vast majority of those are going to come up and be introduced after your February.
And that's what's giving me concern.
Okay.
You know, just an option we never really thought about, but if there's this is kind of so hypothetical, since we don't know what bills and really is there anything important, we're like 8 months away. But all that stuff aside, you can always do your delegation, but you could also do it right here too sometimes, right here and ask for stakeholder input. It isn't like there's another way of doing that.
I'm sorry, Jack, I didn't understand what you mean.
You could still honor, you could still do a delegated meeting of you two here in the boardroom in a public manner.
Oh, yeah.
And take input from stakeholders.
Yeah.
So you get some feedback.
Absolutely.
Yeah.
Okay.
Yeah.
So, and I'm not saying that we're going to have a meeting, but I don't want us to try to set them, if something very big comes up and the board all wants to weigh in on it, and we try to find a date at a late date, we might not be able to find a date that the whole board can come. So I just wanted to ask you if you wanted to do a temporary date in case we needed to have a board meeting. Alrighty, Lynn?
Thanks, Dana. I appreciate the question, and I think that would be a good thing to do, just to set up a tentative date now, because there might be some very controversial legislation next
Right.
year, and there may not be.
Exactly.
Harry?
I agree.
Yeah.
So I think that there's a sense that we want to hold a date. Seems to be the,
Okay. So, Brian, can we do that like through a doodle thing or whatever it is that they do?
Pick a date?
Dates? Yeah.
Again, I think that's within your.
So we don't have to do it now.
No, you don't have to do
We
it
can
now.
send out a couple dates and
Right.
then people can give us input and we can pick the best one.
Absolutely. This
All
is
right.
administrative.
Is the board comfortable with that?
yeah, that's
All
great.
righty. And I didn't explain that very well, guys. I
You did
apologize. I
great.
just wanted to make sure that we had the option to go there if we needed to. All righty.
Just one more thing.
Yeah, Karen.
But the timing of that date has to be important too,
Mm-hmm.
right? I mean, it has to be within a pretty short window, a small window, right?
I would recommend the end of March, beginning of April. If there's new legislation, we have to have time to analyze it, but we want to be able to get our positions out before committee hearings start in April.
All righty. So,
I just remind you, one of the tools that you do have available in this instance is a special meeting.
yeah.
So it is one of the grounds for a special meeting.
And the timeline on open notice on a special meeting is 48 hours. All righty. That sounds good. All righty. Is there anything else? I got to find my original agenda. All righty. Opportunities for the public to make a statement? Anybody care to weigh in on anything? All righty. Then we will call the open session of the board recessed and go into closed session.
Bye, Peter. Thanks for sticking around.